My name is CJ Scott. This is my chapter 20, business law video summary. Chapter 20 was on laws governing labor and management relationships, so essentially the relationship between employee, employer. Um, a lot of this has to do with the rights of an employer, what they're allowed to do with employees, and then I'd say from more of an employee side of things, um, the strongest subject base that's touched on is what can you do as an employee to kind of, I guess, give yourself rights. Obviously, you're going to have rights in employee-employer relationship, but fighting for some of those benefits, fighting for specific things that you might want, um, that's more the employee side of things. As for employers, a lot of this is precedented cases. A lot of this is a lot of different acts, which I'll get into briefly, but it's also the organization of labor. Um, Not necessarily who's doing what job, but what are each of these jobs allowed to do, as well as rewards and punishments within those relationships. So the Wagner Act, or the National Labor Relations Act, guarantees the rights of workers to organize and bargain collectively. Unions being able to fight back, being able to stick it to the man, I guess. But it forbids employers from engaging in specified unfair labor practices. So these are the things that are going to protect you um, as a laborer. So then there's the Taft-Hartley Act, which bars unions from engaging in specified unfair labor practices, makes collective bargaining agreements enforceable in U.S. district courts. So this is almost a fight back to the Labor Act, but it also is gonna help employees and employers. This act will. You could argue that the National Labor Relations Act is going to do the same, but this is more from a employer counterpoint. Unfair union labor practices, restraining or coercing employees in the exercise of their Section 7 rights, bringing people in, forcing the employer to discriminate against employees on the basis of union or anti-union activity, failing to engage in good faith collective bargaining with rights with the employer. These are just going to protect you from very specific relationships within employee-employer, whether that be skilled labor positions or an employer working with a union, workers union of some type, and how you're allowed to manage these employees and what you are and aren't allowed to do. The last one that's touched on pretty heavily is the Landrum-Griffin Act, which governs the internal operation of labor unions, financial disclosure by unions. Majority of these things obviously are dealing directly with unions because it's the employees' way of handling things together, working together essentially. But this one is going to work directly with the union as opposed to identifying different relationships that you're allowed to utilize. This Landrum-Griffin Act is going to work directly with employees and directly with unions. Fighting for equal rights, freedom of speech and assembly, protection of right to sue. So essentially, as an employee, if you're looking at these things from an employee-employee relationship, as an employee, there are times when you may feel unprotected. There are times when you feel like the benefits aren't reaching you. Essentially, what this act does is gives you that umbrella over top of you and says, we can go to war for you. We can go to battle for you in these situations. Obviously, there's fees, assessments, certain things like that. But this act basically allows the unions to directly protect certain employees. There's also the National Labor Relations Board, so an agency set up to interpret and enforce the Wagner Act, which was the very first act that we went over. The functions, they monitor the conduct of employer and the union during an election, preventing unfair labor practices, establishing rules and regulations, interpreting the acts. It's basically a board to protect unions, but also to protect relations between employee and employer. Their jurisdiction, the Relations Board, granted by Congress over any business affecting commerce. I'm not exactly sure what else they're allowed to. Says any business, so I'm assuming that they have almost free reign, um, especially with publicly owned companies or large corporations. Procedures in unfair labor practice cases initiated by employee, union, or employer filing unfair labor practices charge with the appropriate regional office. These are the ways. This is the path to righteousness, I guess, of how you're able to go after an employee or employer or a union if you feel that you've been treated unfairly. Briefly, labor organizing. Dissatisfied employees can contact a national union that represents employees engaged in similar type of work. Labor organizing is not just unions, as I went over earlier, um, but it's also the ability for employees to stand together. That labor organizing is going to allow that to happen. Strikes was a lot on the homework. I apologize because this video is going to go over 5 minutes. Strikes was about the homework, uh, writing an essay on strikes, stuff like that. Temporary withdrawal of labor, economic strike, unfair labor practice strike. There is a list here of unlawful strikes, which is different to me. I had no idea that this was. I didn't know that there was preventative measures when it comes to strikes. Um, Employees are not legally protected, may be discharged by their employer. This basically just allows the employer to have decisions to make when an employee or a group of employees goes on strike. They are allowed to fill your position. You just lost all your rights walking out the door. Sit-down strikes, employees remain on the job but cease to be working. Partial strikes, only some of the workers leave the job. This was kind of what I dug into on the homework, me personally, was partial strikes are not going to be effective. Strikes in general today won't be too effective, but all the strikes that have been effective in the past, you need the entire workforce. You need everybody to rally together. Boycotts, refusal to deal with, purchase goods from, or work for a business. You see this a lot with older generations. They're really good at this. A lot of people are just buying things if the tag says USA. Things like that. Picketing, stationing of individuals outside employer's place of business to inform passerby of the fact of the labor dispute. It's very similar to a strike, only you're trying to present things to the media, you're trying to present things to other people. So global dimensions of labor management relations. This one is different because obviously those laws are going to apply to companies that are outsourcing in different countries. Many U.S. and multinational corporations seek cheaper labor overseas. As I just went over, labor laws of other countries may be different from those in the United States. But some of these laws that are protecting the employees are universal. But are they followed? I'm not sure. Are they enforced in other countries? I'm not sure. That doesn't really go over this too much, but there is protection over companies that are outsourcing their jobs. I'm just not sure how much it's enforced. Essentially, that's it. Chapter 20 was a lot of detailed information that needs to be followed. But information to me that may not be useful as it applies to me using it, but useful in the fact that I can understand how different companies, corporations, institutions are operating. Just having an understanding from a global perspective that these things are happening, to be aware of them, and I guess knowing that as an employee or an employer, you have protection. Thank you.